Hi, thanks for joining us live today. My name is Emily Newman. I'm an immigration attorney with Reddy & Newman PC and also the author behind ImmigrationGirl.com, the blog that brings you practical information from the desk of an immigration attorney. I'm also here with my partner, Rahul Reddy.
Hi, this is Rahul. I'm an immigration lawyer. I'm partner in Reddy & Newman PC. We have established from 1997. We're a team of 14 lawyers, plus we have a support team of approximately 65 people. I know that we're trying to address most of the questions in the Facebook and other live videos. But if you are unable to get your questions answered, you can make an appointment at rnlawgroup.com, and you can go to an appointment. You can make an appointment with me, Emily, or anybody else in our office. The questions that are asked here and answers that were told here is for general purposes only. If you need any specific immigration purposes, we recommend that you contact any immigration lawyer.
All right, so there's lots going on, or lots of rumors, things going on in Congress with immigration laws, bills that are proposed. Can you give us an update?
Emily, there was an expected legislation that was supposed to be voted in the House of Representatives. It was being postponed because they didn't have enough votes. Mostly it was addressing about the border wall and the DACA immigrants, those people who came undocumented. It has also issues about DALCA. That means that those people who are young kids in United States, who are legally in United States. The Congress thought that if we are going to give employment authorization or any benefits to the undocumented aliens, why not address those people who are also legally in United States? But it has been postponed because of a lot of different politics that are involved in there. However, please note that in the next 1 to 2 months, we're expecting a lot of action on the immigration in the Congress. So be aware, and please try to contact your congressman for any of your favorable things that you want to get it done.
All right. Some news going on this week as well as we started receiving our not selected H-1B petitions back in the mail. So from those that were filed in the CAP back in April that have not received receipt notices, now we're getting the return petitions back in the mail, just a few so far. Probably it's going to take another 4 to 6 weeks for us to receive them all. It's a very slow process.
So Emily, how many rejections have you received it?
3.
Oh, whoa.
So it's just the beginning.
So you have a lot of rejections yet to come, but you haven't received it at this point of time.
Correct.
So, right? So we are expecting those anytime soon. Is there any reason why it's been a delay? Because last year by about this time of June 26, we did receive a lot of rejections in the lottery by this time.
Yeah, it seems like it's about a week behind where it was last year. I think we received our first return petition around June 15th last year. So I wouldn't say it's really that far behind. I think I wouldn't read anything into it personally.
And Emily, if a person has not received the rejection yet, is there a probability that the person could actually get the receipt notice now, after all these days now?
I think it's pretty unlikely. There's not like a wait list where they send some receipts first and then others later, or they wait and see if some get withdrawn or denied and then they send more. There's nothing like that. So they send them all out at once and then they start sending the return petitions. So if you haven't received a receipt, unless there was some kind of mailing error, it's very likely that you were not selected, especially if your filing fee check was never cashed. Then you definitely were not selected.
That's a key thing that you need to look into. If you have not received the receipt notice, check to see if your lawyers or probably your employer filing fees receipt notice has been cashed. If it's cashed, then you probably are good. If not, I mean, we haven't received a receipt notice from past 3-4 weeks now. So it's very unlikely that you are. Now, Emily, come to the hot topic of today is the H4 EAD. We circulated the information to a lot of people that the H4 EAD new regulations are going to come in June. Does it mean that the regulations are already out, the proposals are out, or what is expected in the H4 EAD in the future?
So we were expecting, based on the regulatory agenda, that the actual proposed regulation would come out sometime in June. That's clearly not going to happen. We have not even submitted the regulation proposal to the OMB yet, and that is a required first step. So it's June 26th, it's not been submitted to OMB. There's no way a regulation is going to come out in June. So it does seem to be delayed, but that's totally normal in the regulatory process. Nothing to be concerned about. I don't think it means they're changing their mind. As far as everything indicates, they're still planning on going ahead with that proposal. So it's just a matter of putting it all together and getting it submitted to OMB. After it's submitted, probably is going to take 30 days or so for them to review it and then publish it. Again, we'll have the 60-day comment period where the public can submit their comments on that. They have to review all of the comments. That takes months before they can come up with a final rule for the regulations. That final regulation then has to go back to the OMB for review, another 30 days or so there, and then it finally is published and takes effect. So we've still got a months-long process. It really hasn't started yet.
Did you say month-long process or months-long process?
Months, multiple months.
Okay.
Yep, so nothing's changing anytime soon.
And the last time when they actually wanted to issue the H4 EAD, it took almost 1 year for them to complete the whole regulatory process. If by any chance you are eligible for the H4 EAD, please apply for the H4 EAD. Don't hesitate to apply. If you're eligible for the H4 EAD extension, please apply for it. Emily, when the regulations are going to come in, are they going to invalidate all the H4 EADs? What did they do with the DACA when they removed it? What did the administration do?
Right, we don't really know until they propose the regulation, and then there'll be an opportunity to comment on that transition period for what they're going to do with already issued EADs, what they'll do with those that are already filed but not yet approved, and then for those that haven't filed yet. Based on what they did in the DACA situation, they allowed all of the existing EADs to continue till they expire. Those that had already been filed and pending were eventually approved. Just no new applications could be filed after that point. So if we compare to that, I would expect something similar. I think that from the business side, employers would probably not appreciate losing their employees without any kind of advance warning or ability to replace them. So I think they would have a lot of pushback from businesses who don't want to lose their valuable employees if they were to just make them immediately invalid. So I don't think that's going to be the case.
Emily, the million or $1 billion question that seems to be that a lot of people are here on student visa. As you know that there is an OPT that's allowed after the person completes a bachelor's degree or a master's degree, and they're allowed to have a STEM extension if they have a degree in the STEM field and their company is an E-verified company. We have a process because of these consulting companies employing individuals at third-party location. If the person is on the STEM OPT extension right now, the 2-year extension that's granted by the regulation, can they work at the third-party location or can they not work at the third-party location? If the STEM people cannot work at the third-party location, is that only applicable to STEM extension, or is it even applicable to the OPT people also? They cannot work at third-party location. Can you throw some light on this?
Right. So if you look at the regulation that created the STEM extension, if you look at the guidance from ICE, yes, you can work at a third-party site while you're on the OPT STEM extension. If you look at the USCIS website, the answer would be no. So which one controls? That's the $1 million question right now. I think that it is difficult for the agency, USCIS, to claim that they can change a rule or interpretation by simply posting on their website, especially where that rule contradicts with what is in the actual regulation. The regulation does talk about it, but it says that it is allowed as long as there's a bona fide employer-employee relationship.
And Emily, with regards to the recent interpretation of the USCIS on the website, have you noticed any denials on the H1B? Have you noticed any RFEs on the 765? Have you noticed anything with the universities not giving permission for the student to work at third-party location.
Right, so we have received some requests for evidence on the H1B applications where there's a change of status request from F1 to H1, and the documentation shows that the individual is on the STEM extension and must be working at a third-party location. Their address doesn't match up with where the petitioner's address is. So the USCIS does refer to the guidance on their website and says that third-party placement is not allowed. They ask for a bunch of documents, but they don't really give you any opportunity to argue that it should be allowed. It's too early for us to have any kind of results from responding to these RFEs yet, so we kind of have to wait and see at this point. As far as I-765 applications for the STEM extensions, I believe some people have received requests for evidence on that as well, not particularly pointing out the language on the USCIS website, but just asking for general documentation about how the employment qualifies for the STEM extension. As far as I'm aware, those have been being approved. Also getting reports that some schools are not issuing the I-20 for the STEM extension for those that are showing that they're going to be working at a third-party site. So it's pretty much all up in the air right now.
Yeah, I've also noticed that some of the universities are calling the students right now to update the 983 and telling them they cannot be working at third-party location. So these things are spreading around until it seems that something is going to happen either in the court system or the USCIS confirms what's going on. But at this point of time, a lot of people are in trouble. Those people are in the STEM extension when the universities are rejecting them to allow them to work at third-party location. What is your comment on the day one CPTs that some of the students are going because either they did not get into the lottery, they didn't have a job opportunity at the time of March 31st to file a H1B. Is that something legal where they can just get a day one CPT where they do only go to college once in a month?
Whether it's legal or not is probably difficult to answer. It's certainly something that is on the radar of USCIS and Homeland Security. I think that the general rule for grad school is you have to be enrolled for 1 year before you can do any type of practical training, unless you meet a particular exception, which is for your particular program requiring immediate participation in curricular practical training. So many schools are saying that their programs require it and therefore offering that to the students. But it seems that the programs that they're in are almost designed to be work permits with a little bit of school on the side. In that situation, I think it's clearly against what the Congress intended, what the regulations intended when they allow for CPT and allow for F1. The purpose of the F1 is to be a student, not to continue working. And so I do think those programs are problematic. We see requests for evidence on them every year in the H1B area, as well as later when you graduate and apply for an OPT. We also see requests for evidence asking how that CPT was actually authorized. And I think now when we have a proposed memo expected to come out on August 9th, which now would make a violation of F1 status unlawful presence. So we've seen in the past where these day one CPT programs have led USCIS to the conclusion that it was a violation of status. Going forward, after August 9th, assuming this memo comes into play as it's written, that violation of status is going to become unlawful presence from the day the CPT began, or August 9th, depending on the situation. So this could be a major impact on students that used this day one CPT going forward because of this potential new guidance coming out August 9th.
Vishy has a question with regards to that one of his relative H1B extension got denied and his I-94 expired and he is married to a US citizen. Can he file the green card application? The answer is clearly yes. There should not be any problem in getting the green card. However, if he has any travel plans, he should not make any travels. He needs to check with his immigration lawyer before he makes any travel plan. But just because his I-94 is expired should not cause any problem. If the marriage is genuine, they're living together, have babies, we don't see any problem in them getting the green card in there. Ajay has this question, Emily, is that the salary is $65K and he's actually getting $90K as in the LCA, the salary is $65K and he's getting $90K. Will that be a problem anywhere?
Yeah, I definitely think it could be. When your employer is submitting the LCA, they have to list the actual wage offered, and they are confirming that the information in the LCA is accurate and certifying that when they submit it. In addition, they submit the same information to USCIS showing that the salary is going to be $65,000 when in fact they're paying a lot more than that, say $90,000. That calls into question whether the LCA was properly submitted, whether it was accurate, whether the wage level was selected properly. Because if you're really doing $90,000 caliber work, perhaps it should be a level 3 or level 4 wage, which your salary might actually be less than what's required. Maybe the level 3 or 4 wage is actually 95 and you're only being paid 90. And so for some reason your employer picked 60 to try to get around that. So it definitely can be a problem in a wage and hour audit from the Department of Labor, and also could be questioned by USCIS.
I've seen one that when the person went to the stamping, he got stuck there. Actually, he just called me today, Emily. One of the other reasons why the US government is concerned about when the salary is less on the LCA and you're getting paid more, they're concerned that on the LCA, the company is notifying the public that this is a salary that they are paying. And if there are any US workers that are getting affected negatively getting affected, they should notify the Labor Department or the employer. So when the employer is listing $65K and actually paying $90K, the US government is concerned that you are listing $65K for the purpose of the US workers, but you're actually paying the immigrant worker $90K. They do have a problem with that. So I would recommend that you check with the immigration lawyer, and if needed, maybe to file an amendment for the particular things. We have noticed now until about 2016, we didn't notice much of an issue in those things, but we started seeing those things in 2017 when a person is getting paid. We have problems at the USCIS, we have a problem with the CBP, which when you're trying to enter into the country, we have a problem with the stamping. So if you're getting paid higher, way higher than the LCA, there is a problem. Now, if the salary is $65K, and I guess if you're getting about 68, 70, maybe that should be okay, because that seems to be a natural increment in the salary. But if it's $90K, definitely that looks very problematic. You need to check with your lawyer.
Chaitan has a question for us live here about the 60-day grace period. So he's on an H1B that's valid until 2020. Looks like he's getting terminated before that. And so let's say his employer is planning on withdrawing his H1B and terminating employment July 15th. Does the 60-day grace period allow him to?
Yes, for Chaitan it's definitely applicable, Emily. The reason is that he has the I-94 until 2020. That means that after he's been terminated, he still have more than 60 days of the I-94 period. So definitely 60-day grace period is applicable to Chaitan or anybody else whose I-94 is expiring beyond the period of 60 days. So the problem comes when the I-94 expires and they get terminated or their extension get rejected. When the I-94 expires, that 60-day grace period is not there. Since his I-94 is not expiring until 2020, he definitely gets a 60-day. Srujana has this question, Emily, that she has the amendment pending. While the amendment is pending, can she transfer her H1B to a different company, or does she have to wait until the amendment is approved?
Right. So in our experience, you can file a transfer while you have an amendment pending. Generally, you would have an underlying H-1B approval that's valid still, and the amendment is what allows you to work pursuant to the new terms and conditions once the amendment is filed. So you are working for the employer pursuant to the amendment, but your underlying petition is also valid, and you can file a transfer based on that. No issues with doing that.
Mahesh asked this question live, Emily, is that his OPT is expiring in July 6th. Can he join another university for a PhD, or will that be any problem?
Yeah, so after the OPT ends, you have the 60-day grace period for F1 students, and during that 60 days, you have the option of enrolling in a new program, filing a change of status to any other type of visa that you may be eligible for, or preparing to leave the country. So yes, you can enroll in a new program at a PhD level and continue your studies. You don't have to exit the country to do that. You just obtain the new I-20 from your new school to continue your studies.
His visa has expired. Will that still be any problem, or he can proceed as it is?
Right. So even if the visa stamp is expired, that's fine. The visa stamp, you only need it to be valid when you're entering the country. Once you're here, it's your I-94 card that determines how long you can stay. So for students, they're normally issued an I-94 valid for duration of status, or D/S, meaning that as long as you're maintaining your F1 status and you have the valid I-20, you're considered to be in status, regardless of what happens with your visa stamp. So now if you were to travel, then you would need a new visa stamp to come in. But since you're already here, you don't need the visa stamp anymore.
Sagar has this live question from Sagar is, he's on H1B, he wants to convert into F1 visa for a PhD. Does he need to go back to India to get an F1 visa, or he can get the status change here? Sagar, this change of status from H1 to F1 used to be an easy process until about 2016. But since the new administration came into picture, they changed the complete F1 process. Previously, when the F1 was applied, they used to take about 3-4 months for them to change the status from H1B to F1. But nowadays, they are taking approximately about 12 months, in some cases all the way to 24 months. And they not only are taking, they want you to maintain the status until you get the F1 status. So for example, if you're on H1B, you're applying for change of status to F1, you can keep on deferring the admission of the I-20, but you need to maintain the legal status until you get the F1. And that becomes sometimes tough. Your H1B might be expiring, or you might actually leaving the job. So there are some issues that will pop up. You have an option of going to your home country and getting the stamping, but what if you don't get the stamping? I would recommend that you check with an immigration lawyer before you move to F1 from H1B. This was a simple, easy process in 2016, but it has become so complicated. Sometimes when the people are moving from H1 to F1, we are ending up filing a B2 to transition between the H1 to F1. And since the F1 is taking a longer period, we are only filing B2 or B1 visa for only 6 months. Since F1 is taking up to 1.5 to 2 years, we are extending the extension which is already pending. So we file a B2, we extend it and then extend it, and then F1 gets adjudicated. It's taking a long, horrible time for getting an F1 visa, not unlike before.
Are you seeing any new trends in H1B RFEs now compared to 6 months, a year ago?
Yes, Emily. Last year we have noticed a lot of wage level 1 RFEs. And also somewhere in August or September of 2017, we started seeing the computer system analyst. The titles got into big trouble where the companies have filed H1B with computer system analyst. However, most of the companies and the lawyers did avoid filing the H1Bs in level 1 wage, and most of the companies did avoid filing the system analyst positions. So those kind of RFCs kind of withered down though. But we still are getting good amount of RFEs, particularly on the issue of the specialty occupation, whether the position requires a specific degree as a minimum requirement, whether the employer, when the employer is placing an individual at third-party location, whether the employer has the control over the employee. We're also noticing a new RFEs right now, which we have never seen before. They're asking about whether or not a person maintained his legal status when the person is working on a STEM extension at a third-party location. So To give a surprise to this year though, I would point out that the STEM extension people getting an RFE on whether or not the person can work at a third-party location seems to be the surprising element this year. Now, of course, the specialty occupation right to control was an issue before. It has become a little bit more as an issue right now, but nothing surprising. But this year, the surprise seems to be coming from the STEM extension part of it when the person is working at third-party location.
All right. Kishore has a question about what happens to the H4 and H4 EAD when the H1B spouse files a transfer? Does the H4 EAD remain valid? Do they need to file a new one?
The H4 and H4 EAD is still valid. Absolutely no issues with that thing. However, if you want the H4 and H4 EAD to be extended beyond the time what they already have, then you might want to file the H4 and H4 EAD. For example, if your company A's H1B is expiring in 2019 October, and now you're moving from company A to company B, you're going to file, because your I-140 is approved, you're going to file for a 3-year extension. So you're going to ask for an extension from 2018 to 2021. So if you want your spouse to get the H4 extended until 2021, EAD extended until 2021, you can file your H1B, you can file the H4, you can file the EAD at the same time. Now, even though it is not the company's A's I-140 that you're filing a H1B with company B, it's not a problem. Your spouse is still eligible to get the H4 and EAD extension. You could always do it, and at any time before October of 2019, you can file it. You don't have to file it right now. Assuming that the H4 EAD and H4 is expiring in October 2019, you could always file it at a later time. But because there are some issues with regards to whether or not the H4 EAD may or may not continue on a long-term basis, if I were you, I would file the H4 and EAD right now and get it extended right now, Emily.
All right. Sujana asks, what's the current time period for amendments to be approved right now? I'd say anywhere from 3 to 8 months. Really depends on the service center, depends on whether there's a request for evidence, but it's not a fast process.
Yeah, if it's a request for an evidence, then the whole clock starts all over again. So it might be a long process. Srujana already has plans to move to a different company. So while the extension is pending, you do not have an issue of moving to a different company. However, please note it down that this process, when something is pending to move to a different company, is only allowed when you are filing an amendment. That might not be true when you file for an H1 extension. Your I-94 expired. There are some issues with regards to whether you are going to get an I-94 with company B. And also when you move from company A to company B, and then now you want to move to company C while company B's change of employer is pending, you will have an issue when you move to company C. But when it's an amendment and extension is pending, we don't see any problem in getting the change of employer or anything.
All right, Gopi has a question. Welcoming me back. Thanks. It's good to be back after a week off.
The audiences went up very significantly since you're back.
Well, thank you. His H1B cap subject petition got transferred from California to Vermont. Is that a problem? Which one's better?
That's not a problem at all. We have seen a significant number of cases that are getting transferred from one service center to another service center. When one service center gets filled with more cases, when the officers have more caseload, it's natural that they transfer the case to another service center. Nothing wrong with it. It's just natural. You don't have to worry anything about it. Now, which service center is better? Do you want to answer that question, Emily?
I think they're all about the same nowadays.
Which one is better, 5149? It's very tough to answer. Sometimes one service center behaves good, sometimes other service center behaves better. We cannot tell. It depends on mostly on the officer, though.
Yeah. Sriram has a question about filing a change of status from H1 to H4 EAD. Do you lose the H1 as soon as the H4 and the H4 EAD are filed? No, in the H4 application, you can actually request a specific start date that you want the H4 to take effect. So if you choose a future date, then you can continue on your H1 until the H4 change of status is approved. Generally, the EAD is approved along with it, so you can go straight from H1 to H4 EAD all at the same time. But you've really got to think about the processing times for the I-539 application, which is the change of status from H1 to H4. That's taking 8 months right now, so you really need to file way early to ensure that your H1 doesn't expire while you're still waiting for the H4 and EAD to be approved.
Devika applied for a H4 EAD and EAD renewal and got an RFE with regards to the status of the H4 is missing. That's kind of rare RFE. Most probably they missed something out. If you file for an extension, they should have the I-94 and everything with it when you file for the extension. But I want you to answer the RFE very carefully, because they might be asking not just the H4 status, they might be asking whether or not your spouse is maintaining the H1B status, whether the pay stubs are there for him. Those are important too. So you might want to submit the documentation, and also submit the documentation that you are still married with your spouse. So marriage certificate, and probably I even want to put living together documents too, that you both as a couple are living together, because to maintain the H4 status, you must be married to a H1B person, and the H1B person must be maintaining the status, and also you must be living together with that person. So I will put all those things to answer those questions.
All right, we have a question about the 24-month STEM extension, the RFEs that are coming on the H1B about working at a third-party site. What are the options? One of the possibilities is to convert the application to consular processing instead of requesting a change of status. That is something that is very much case specific, so I would recommend you and your employer reaching out to your attorney or a qualified immigration attorney to discuss those options, because it really depends on a lot of factors and isn't something we can answer generally for the whole audience.
Sudhir has this question. His I-94 is expiring in September, and his company filed an extension. Can he change the company at this point of time? Yes, you can. I don't see any problem. If your I-94 was expiring before you change to another company, that is a problem, though, if the extension is pending. But if your I-94 is expiring when you say September, I'm assuming that you're telling me that it is September of 2018 that the I-94 is expiring. Then I don't see any problem in you changing from company A to company B while the extension is pending. Now, is there a problem when the extension and the transfer gets hit to the USCIS at the same time? No, they like the money that you pay, or your company pays, sorry.
All right, we have a question about processing time for extensions and what happens if the extension is denied. So first, the processing time is quite long. It's still anywhere from, I'd say, 3 to 8 months, depending on whether there's a request for evidence, depending on whether it's filed in Nebraska versus California or Vermont. So I would definitely recommend filing early. You can file up to 180 days in advance, and please file in premium processing so you avoid this issue altogether.
Whoa. Emily, isn't that premium processing means it's a guaranteed RFE and guaranteed denial?
No, definitely not. Yeah, everyone's getting requests for evidence, but you're going to get it in regular processing anyways, and you want to make sure, my recommendation is get the decision before your current I-94 expires. In that situation, if a denial happens and your existing petition is still valid, you have time to come up with different options, time to refile, time to file a change of status, time to make other plans. If your extension gets denied after your I-94 expires, you're immediately out of status and immediately accruing unlawful presence. Your options are much fewer at that point, and you may have to leave the country without getting your extension.
Nikhil has this question that when his H1B amendment has been filed, can he start working as soon as it's been filed? Does he have to wait until the amendment is approved? You can start working as soon as the receipt notice has been received. You don't have to wait for the approval if it is for an amendment. Absolutely not required for an amendment to be approved. You can start working. Covey has this question on live, Emily, is that she applied for the H1B, it's been selected in the lottery, now she got an RFE saying that the location that has been listed in the 983 is different than actually where she's working. Will that be any problem in responding to the RFE? So what it means that the company filled the 983 and said that the location, let's say for example, is Dallas, but she's actually working in New York. Will that be a problem in responding to the RFE?
Well, I guess I'm unsure where they got that 983 information
That's
from.
very surprising.
Because you don't normally submit the 983 to USCIS when you file an H1B petition. So if they're looking at the SEVIS system and it's different, it really just depends on the situation. Was it a mistake? Is it actually different? Is there a good reason for it? So I think it's hard to answer that, but it would be surprising to me that the USCIS has access to the 983 unless you proactively submitted it.
One of the things that I'm concerned about, Covey, is that this might go to denial of the I-94 though. You may want to consult with your lawyer in strategizing your H-1B application in probably requesting the USCIS to adjudicate the H-1B as a consular processing, avoiding the complete topic of your legal status. That might be a strategy you might want to discuss with your lawyer though.
All right, I saw a couple more questions about H4 EAD before we wrap up here. So as a reminder, nothing has been proposed yet. Nothing has been submitted to the OMB for review, which is required before a proposed regulation can be published. So we were expecting a proposal in June. That's clearly not going to happen. It might happen in July. It's normal that things like this get delayed. So at some point, we do expect still to have a proposal issued that will rescind the H4 EAD. Once that proposal is issued, it does not do anything immediately. All H4 EADs remain valid. You can continue to file even after the proposal is issued. It's just a proposal. You'll have the 60-day comment period where the public can comment for or against the proposal. Then there will be a months-long process of USCIS reviewing all of those comments, determining what the final rule will be, and then issuing the actual final regulation to rescind the H4 EAD. After that point, there's usually an effective date where the rule will actually take effect, and in that final rule, they will generally give us instructions about what happens to those EADs that are already approved, what happens to applications that are currently pending, and what happens if you have not yet filed. So we don't know any of those answers right now. Our best guess is that the H4 EADs that are already approved should remain valid until they expire. That is a guess, but that's just based on what we've seen in other areas. But again, until an actual final regulation is published and takes effect, nothing has changed. The H4 EAD remains valid. You can still apply for it. They're still approving them.
Mohammed has this question. If the person H1B transfer from company A to company B has been rejected, can he apply a change of employer to company C? Well, it depends on if you actually join the company B. If you join the company B, you might be having some issues transferring the company to company C. There are certain provisions that may allow you to transfer to company C. We call them as non-protunct. What does that mean is that if you're out of status, you could be excused if it is beyond your control and it has been under extraordinary circumstances. Particularly, you don't have a control on whether the H1B with company B is going to be approved or not. So that can be used, but we have to be very careful when we are using this argument. I would request that if you come into the situation where the company B's transfer has been rejected and you are contemplating in filing a company C, please check with your lawyer to see what are the risks involved in it, what are the rewards in it, are there any alternative plans, maybe H4 or other plans, other alternative plans where you can go to India and get the stamping. So a lot of things need to be evaluated if you want to move to company C. Now, if you don't join the company B, when the company B's change of employer is rejected, then you're fine. We don't see any problem in moving to company C. But if you join company B and company B's change of employer rejected, you might have some issues.
All right, well, I think it's about time to wrap it up for today. If we did get to your question or if we weren't able to answer it thoroughly, please feel free to visit our website, rnlawgroup.com, where you can schedule a consultation with either of us or any of our attorneys at Reddy & Newman PC, or feel free to log back in next week. You can also continue to ask your questions on Facebook, and we'll try to get back to them as soon as we can.
Thank you. Thank you for logging in, guys.